Hi, everyone. Welcome back to the 2022 Elder Justice Conference. Thank you all for being here today and joining us for Alternatives to Guardianship. In this session, we will focus on the alternatives to guardianship that can be put into place to assist seniors with understanding all of the risks and benefits of the decisions that they make about their life. Before we get started, a few announcements that I want to make are, first and foremost, is we do have a live captioner who is joining in on this training, on this webinar, and writing down everything that's being said. If you're having any issues with the audio and you'd like to put onto live captioning in order to assist you a little bit better, please feel free to, on FeedLoop, you'll scroll down below the video that you see here, and there will be a blue box that says Show Captions. If you click that blue box, another box will pop up and you should be able to see the transcription. If you have any issue with this, please feel free to write me in the chat. Additionally, I just want to cover some Q&As. Our speaker has graciously agreed to answer Q&As in live time. So if there's something that comes up while a topic is being covered and you'd like to ask it, please feel free to drop it into the chat or the Q&A, preferably the chat, but either way, I'll be monitoring both of them and I'll find the right time to interrupt our speaker in order to get your questions heard. So without further ado, I'm going to introduce our speaker. Our speaker is Shannon Miller. Shannon is a Florida Bar board certified elder law attorney at the Miller Elder Law Firm. And without further ado, the floor is yours, Shannon.
Thanks, Alexis. Yes, I am Shannon Miller. I work for the Miller Elder Law Firm. And I want to encourage you guys. I know that sometimes these guardianship lectures can be a little dry. So I would really like to encourage you to ask questions. So I know you're alive out there, and also so that we can, as things come up for you, you may have a question that someone else has. So I find that these programs can be a lot more engaging if we interact. So if that is something comes across your radar and you're like, what about this? What about this? Well, I've had this situation. I can't get too sidetracked into fact-specific issues, but as you have questions, please put them in the chat or in the Q&A. All right, so let's get started. I had the pleasure of serving on the clerk's guardianship task force during this last year. And what we did over this last year was really kind of dig in a bit to some of the problems that exist in guardianship that have existed for a long time and have to some extent hopefully been addressed with some of the law changes that have happened over the last 10 years. There were some really big changes that happened in guardianship in 2015. I may hit on a couple of those today, but I would say that the majority of concerns that involve guardianship proceedings are very, it's very challenging to have a guardianship in place. And I think a lot of you who practice in the field of guardianship or who have family members who've been through guardianship will recognize that guardianship it's really awful. I don't know how else to tell it to you, but guardianship is not fun. I think many of us who practice in this field will do everything possible to avoid guardianship. And so I think you see a lot of the changes that have occurred in the laws have really been trying to find ways to avoid guardianship. And so really looking at the alternatives to guardianship and trying to avoid having a guardianship is absolutely been one of the goals. And I think that was one of the issues that was raised significantly during this task force, trying to make this process friendlier to families and also friendlier to our, cherished little person who's going through this process. So let's talk about, generally what happens in one of these cases. And I'm just going to give you guys a hypothetical to start things off. We get a phone call in our office, and it is a family member who says that their loved one does not have any estate planning documents and they need a guardianship. And that's usually what people will say. They've heard they need a guardianship, somebody, their neighbor or their friend, or maybe a nurse at the hospital has said, they're not going to be able to make decisions for themselves and you need a guardianship. And so they call our office really sure that what they need is a guardianship. So one of the first things I do in that situation is, I try and figure out, what's happened and what is happening. And so for a lot of them, it's a situation where bills are not being paid, where the person has had a stroke, or they're being exploited, or any other variety of reasons why, they may have an alcohol problem that has created a dementia issue. They may be, under this situation where they're about to leave the state and go to a different state because they've been told by an exploiter that would be a good idea. We do not have uniform guardianship jurisdiction laws in Florida. So that has become more and more of an issue. I had a case recently where, we've had to stop that from happening, where one of our clients was actually about to be taken out of state with the intention of opening a guardianship in another state. And so there's a lot of reasons why we get that initial call. What I do during that initial call is really, I try to figure out, does this person have to have a guardianship at this point? If they're in a coma and there's no options for any other type of planning for that person, and they won't necessarily qualify for some of the other alternatives to guardianship, then I'm probably going to be pretty quickly pivoting towards looking at this process for guardianship. But in every other case, I am going to try as hard as I can, as well as every other elder law or guardianship attorney in the state, to avoid guardianship at all costs, right? So, someone says, my dad needs a guardianship, he has dementia. And I might say, well, let's look at that, because the capacity that's required to execute a durable power of attorney does not mean that if you have a dementia diagnosis, even if you had that diagnosis for a couple of years, that may not disqualify you from having testamentary capacity to assign someone to help you with financial decision-making. So especially if there's a previous durable power of attorney in play. So let's get to the basics here. What is a durable power of attorney, right? It's a legal document that allows our principal person, I'm going to put him or her over here, to, when they sign the document, their financial powers, and it's all financial powers. It's not medical powers. It's not where you live. It's not personal powers, but it's all financial powers under Florida Statute 709. When they sign that document, all of those powers become available to our agent under power of attorney. So our person here continues to have authority to make decisions with regard to finances. When they sign the document, that new person also has authority. If they have that document, they also have financial decision-making authority. So the durable power of attorney is an incredibly powerful tool. A durable power of attorney, these powers that started with our principal continue even when our principal has incapacity. So there's provisions in that document that say, even if I cannot make decisions for myself anymore, I want the authority that I've given to my new person to continue. So this person's authority may eventually stop because they can no longer exercise their financial powers, but the ones with our new person, our new agent under power of attorney, can continue. So a durable power of attorney is a great document. Now, it's also like the most dangerous document that there can be, right? So we know that a durable power of attorney can be, you can take it into the bank, you can clear out somebody's bank account. It's one of those tools that obviously our exploitation laws, if you don't use the power of attorney either in the best interest of the principal or for the benefit of the principal, then you've committed the crime of exploitation. So we want to be careful who we give power of attorney to, but at the same time, it can prevent us from having to go through a guardianship process. So what is the capacity required for a durable power of attorney? Well, we know that the capacity that's required for a will or a trust-based planning, there's really two things that we look at for that kind of planning. We look at, do you know the nature of your bounty? So that means, do you know what your stuff is? Do you know what all your assets are? Do you know that you have a home, you have an IRA, you have a car? Do you understand what your stuff is? That's number one. Number two is, do you know who you want to give it to when you die? You know who wanted to receive your bounty upon your death. And so, those are the only two requirements that we have in Florida for testamentary capacity. It doesn't say, do you know the nature of your bounty and who you want to receive your bounty upon your death when you're an hour after signing the documents? That's not a requirement. The question is, do you know those two things at the time that you execute the will or you execute that other planning document? So when we convert that over to the testamentary capacity required for a financial power of attorney, and then if we layer on that, you had a previous power of attorney that may be outdated or maybe didn't have all the provisions that would help you to actually administer your affairs, the standard is quite low. So if I go in and I talk to a client and, I'm really trying to find out, separated from any other family members, right? We never want anybody else in the room when we're talking to our clients, because we want to make sure that we have attorney-client privilege and that they're not being unduly influenced. But I will typically talk to my client at least two times. One before, when I initially meet with them. Sometimes I'll talk to them before I come out to do the signing, to review the documents, and then I will talk to them again at the actual signing of the documents. But I'm making sure in all of those situations that I'm speaking directly to the client without anyone else around, not even sometimes in the waiting room. If people bring our person in, I will send them out to get coffee, or, I try and get them away from us. And then I try and take my time and I tell them a story about, my client who I had, who came into my office, and I got rid of the daughter. And, the daughter was telling me that mom wanted to change her will to leave everything to her. And as soon as I got her out of the building to go drink coffee, the mom said to me, I don't want to change anything. So, it is interesting that when we get our people alone and we start to really ask them, are you afraid that, this is being forced? Are you being coerced? Do you have fear of, repercussions if you don't do what your person is asking you? Like really trying to vet those issues. But if I can get my person in there and I can understand that they really do want this person who's been named the agent under power of attorney, and they seem to understand the impact of that document, and they also seem to have the lucidity that we've talked about with, the testamentary capacity. They know what their stuff is and they know who they want to give it to. I'm likely going to feel comfortable, even if they have dementia or they have some other type of, brain issue. I'm usually going to be pretty comfortable with them executing that document. Now, I'm probably going to spend a little more time with them if they have a diagnosis of dementia, or they have some other neurological diagnosis. I'm going to talk to them like, who's the president? I'm going to ask them, maybe some mini mental status exam questions about, I'm going to tell you three things and I'm going to ask you 2 minutes later if you remember those three things. I may even have them, do some exercises like draw a clock face, but I'm not a trained psychologist, so I can only do my best. And a layperson's interpretation of capacity is actually valid and admissible in court. So when I do these things, I'm usually thinking about how would I be able to testify to their capacity if this will or durable power of attorney was contested. Excuse me. Some people might ask, like, why don't you have a psychologist in the room with you? Why don't you videotape the signing? All those things, can sometimes be appropriate. I don't usually use that in my practice. And the reason for that is you can, cut and paste and take things out of a whole interaction that you might have with the client. And it might very well make the person look like they're incapacitated. Whereas if I'm meeting with that person, and sometimes I will bring a doctor, I do have a doctor that I use on occasion when I have concerns, I may bring them into the signing. to do a full examination and maybe even a mini mental status exam on our person right before they do the signing. And then I have the doctor sign an affidavit, but I don't videotape it. I think it's awkward. It makes it not comfortable for the client. But I will do that, go through that assessment because lay people can't assess those issues, and I try and do that. Okay, so we have the option at that point, even though our person has come in and said they need a guardianship, they've been diagnosed with dementia a couple of years ago, and we really need a guardianship. I'm going to run through some of those questions, like, do you think they understand, who they'd want to make financial decisions for them if they could not? I'm going to ask all of those types of questions, and also ask them what their doctor might think, and maybe have them do some homework and go talk to the doctor if they're the healthcare surrogate to find out, what does the doctor think? Are they capable of executing a durable power of attorney right now? Sometimes I need to educate those doctors. I know the geriatricians that we work with in Gainesville, we've done a lot of education on what testamentary capacity is, because sometimes they think that testamentary capacity is the same thing as incapacity. Incompetent to stand trial, which is not the case, and it's also not the Baker Act, Marchman Act standard of you're a threat to yourself or others. And sometimes people get confused about what those standards are. So sometimes I may need to do some educating with the physician, unless they're geriatricians, because they're usually very good at understanding those issues about testamentary capacity. Okay. So let's say that happens, and we realize that none of those things may be an option. I start talking about, well, okay, what is the guardianship process, right? And the guardianship process is really hard, and it's very expensive. I can tell you generally, right now, it's costing between $8,000 and $15,000, depending on what part of the state you're in, to go from the beginning of the process to the end of the process. And it's not even the end of the process. It's just the end of establishing the guardianship. So in the private practice world, we're seeing filing fees that run about $650 for both the incapacity file that has to be opened and the guardianship file that has to be opened. And then, for the examining committee, it costs about, $2,000 to $2,500. The cost of the attorney ad litem, which is normally privately paid from the assets of the ward, that can cost another, $2,500. And then, of course, there's the guardianship attorney who has to also charge a fee, and that can also be very expensive. So we want, cost is a very big factor here, and not everybody's going to qualify, but it is very expensive to go through that process. And that's only to set up the guardianship. Then you have all the administration that comes after that on an annual basis, because you need to restrict accounts, you need to file petitions to get money out of the accounts, you need to file annual plans, you need to file inventories, you need to file, anything that happens with our ward at that point. Although many of us have hoped to change that titling, we don't really like this idea of alleged incapacitated. I think many of us prefer the term person under guardianship or proposed person under guardianship, because it's just feels better than incapacitated and wards and all that stuff. But once we start down that road of this is really the only option right now, it is important for me to explain to our potential petitioner what a guardianship process will look like. And it's super strict, and 744.331 gives you a step-by-step of how that process looks. We file the petition for incapacity, we file the petition for guardianship, an application is filed by the guardian, we have our examining committee appointed, our court-appointed attorney goes out, they read these petitions to our poor person who has to hear about the fact that they are not capable of managing their own affairs, and here's why, which to me is the most horrible part of guardianship, is that, we have to put our people through this process. That court-appointed attorney is also what's called the elicer, which means that they're charged with actually reading these entire petitions to our person. And then, they also go in, and their job is to be an advocate. Their job is not to work in the best interest of our person. Their job is to be an advocate. So if our person says, I don't want a guardianship, I don't want my daughter to be my guardian, I want my caregiver to be my guardian, if I have to have one, And the attorney for the ward really has to be an advocate for that person, even if they don't think that's what's best for them. So, that's the thing about being a court-appointed attorney, and we take that responsibility very seriously when we're in those roles. So basically, the court-appointed attorney goes out, they may read these documents to our person, the examining committee will go out, they're supposed to go out separately from each other, they're supposed to do separate reports. And then the court conducts, and then they, file their reports. The court-appointed attorney will file a report, and then the court has an incapacity hearing, which, they normally want our people to be there, unless their appearance is waived by their attorney. And again, it's like not fun to go into a hearing and hear about what this examining committee said. You couldn't make a clock face or draw, a square box. So it can be very challenging for our little person to go through. And I always try to avoid it, just because of that. That's like the number one reason that many of us don't like guardianship, even those that practice it. It's because it's just sad for our family. It's sad for our people. And sometimes it's, as a result of exploitation, which we're going to get into in a minute. Sometimes the person who's calling, is not a family member. Sometimes it's an adult protective services investigator who says, hey, we found out this person, has a lot of assets. They're really subject to exploitation. We need somebody to represent them. And so sometimes we come into the case not having been contacted by family. Instead, we have to find family because we still have a duty to notice them. So we may come in and initially have like an emergency situation where we need to point an emergency professional guardian to look out for this person. And sometimes it's someone who comes in who's a neighbor or a friend who says this person's in struggle and they haven't paid their bills and they're about to get evicted. Can you help us help them? Sometimes, out of all these scenarios, you can imagine that there are also exploiters who come in and say, they don't have a way to pay stuff. I'm willing to be their guardian. And, in those cases, you can pretty quickly see someone who's an exploiter and kind of, take charge at that point. But I will say that that does happen on occasion, and it doesn't happen very often, but on occasion. Until you tell them how strict guardianship laws are with regard to the assets are restricted in most cases, and judges want to know about your criminal history. They're going to fingerprint you. They do background checks. Also, you have to basically petition the court every time you want to use a nickel of the money. So, for the most part, guardianship, once it's in play, does protect our people from exploitation. So we get to that incapacity hearing and then we set the case up. But then again, the court has the ability to kind of supervise any monies coming in and out of the guardianship. So that's another reason that's kind of a negative for guardianship, because judges have different ideas about what money should be spent on and what it shouldn't. One of the biggest debates we have in guardianship cases is whether judges will approve like a minor guardianship's assets for the purchase of a vehicle, right? So there are some judges who say, I will never approve money to be used for a child's vehicle when they turn 16 or 17, because that's just my rule. I don't think kids should get cars when they're 16 or 17. Well, there's some other judges who are like, well, they can use the car to go to sports. They can use their mom is working full time because the dad died. And, the mom, there's a whole benefit to that. So you can see that there ends up being like these inequities across the state because guardianship judges have so much discretion to approve or disapprove expenditures. And there's really no standard way of the court assessing, what is in the best interest of the ward. So it's like, okay, do we want a stranger, the judge? I mean, they're always doing what they think is best and they're always trying to do the best job they can. Or do you want a family member who you've kind of thought about when you're capacitated and have them, serve in this role as agent under power of attorney, but also recognizing that those durable power of attorney documents can be very dangerous in the hands of someone who doesn't have good intentions for our principal. So that's step one. We kind of come in and we try to figure out, okay, how are we going to get the bills paid? They're about to be evicted. How do we defend that process? Or, what we see quite often is someone needs Medicaid. They are in a situation where their bills are not being paid, and we've got to figure out how to apply for Medicaid. How do we access the assets to apply for Medicaid? And so, we've talked about some of the downsides. Now we've talked about the process of guardianship in Florida. The one other thing that I, do a lot of when they come in, and I feel like our principal does have capacity, I may go out and meet with them. If I'm going to do a durable power of attorney for them, it's likely that I'm also going to try and have them execute a designation of a healthcare surrogate. And even more importantly, today in our state, a living will that contains provisions for not resuscitating. And I don't know if you guys are familiar with some of the law changes that happened in 2015, but one of the things that changed, actually, I think it was 2018. It was 2018 when the DNR revisions came into play. But basically, if you have a guardianship, you really have to get a court order in order to sign off on a do not resuscitate order. So I always encourage people, get your living will, because the living will, if it has provisions that says, that your agent under your healthcare surrogate can say, I don't want him or her to be resuscitated, then that really does lay the groundwork for the court entering a do not resuscitate order later. But like we just had a situation where we had a client who, I know him, he's told me, I want to be resuscitated forever, and he's so sick right now. And our guardian came to me and was like, the doctors really want to have a do not resuscitate order on him. And she and I have both had conversations with this ward, and we know that he wants to be resuscitated until the very last chance. So as guardians, we also have to honor the wishes of the patient. And so even though the doctors don't like this, we really can't go against the wishes that are very clear of our ward, even though it may result in a death that's prolonged and suffering. We just have to do what's required under the law and what our clients have asked for. But I would say that if you can get a living will, please do that. Okay, so durable power of attorney and a designation of healthcare surrogate and a living will, so important so that we can kind of avoid some of the issues that we might have if we just went and did a full-on incapacity guardianship from scratch without those documents in place. Now, if we have the option as well, if we have a fairly capacitated person who also has testamentary capacity and can express their wishes for what they want to happen to their stuff when they die, we may be able to even do some more sophisticated planning, like using irrevocable trusts. And what is that? Everybody talks about irrevocable trust. What is an irrevocable trust? Well, an irrevocable trust is a way for our principal person to actually fund assets into a trust that then they cannot undo, they cannot unwind. And sometimes that's very helpful if we have a situation where there's like an undue influencer out there. Sometimes an irrevocable trust is the best way to protect our principal person from the undue influencer. So we may put the assets into the trust. We may have the trustee of the trust be someone other than our vulnerable adult. And that way, we've created some protection there. We've created gatekeepers. We've reduced the expenses of going through guardianship, and we've still been able to honor the wishes of our grantor in that case, or settlor. Okay. Also, revocable trusts are not the worst. If our client says, I don't want to do that, I'd rather do a revocable trust. There are successor trustee provisions that can kick in with incapacity, provisions. So you might have in your revocable trust a provision that says, if I become incapacitated and my doctor says it, as well as my wife and my son, or the majority of them say it, obviously the doctor would have to say it as well, then we can have this provision that then the successor guardian takes over, successor trustee takes over. Okay, so that's another option, is using revocable trust-based planning. If our person is like, I don't want to do an irrevocable trust, I only want to do something revocable, you can still use those provisions to allow us to kind of manage the assets of our vulnerable person. But at the same time, if they start to give away the farm, or if they, have a stroke, or they continue to decline because of their Parkinson's disease, then we have a way to kind of avoid guardianship by titling assets in the name of the trust and then creating successor trustees. Okay. All right. We got 36 people out there. I'm not seeing anything in the chat. I'm not seeing any questions as we go along. I hope you guys are awake out there. All right. So this next is the preliminary alternatives before we file. So I just talked about the use of irrevocable trusts with revocable trusts. And also the simplest thing with, kind of planning that I always like to encourage people to look at, and this can be used no matter the value of assets, and that is asset titling, right? So I always encourage people, when we're going through this exercise and looking at incapacity planning, are you also asking people, like, have you named pay on death beneficiaries on your bank accounts? Have you created, and we don't want joint accounts. Usually we don't want joint accounts. It's better to have a durable power of attorney named on an account with our principal, and then having pay on death beneficiaries to avoid probate. And also with regard to beneficiary designations with IRAs, making sure that we are using the strategy to avoid probate, maybe all together with this idea of planning for incapacity. Now, what are some other options to avoiding this guardianship process? And one of the other options is voluntary guardianship. And I'm going to share the screen for a minute and talk about 744.331, which is here. Okay. So this is a voluntary guardianship statute. And I've highlighted the parts that are important, but basically for a voluntary guardianship, what it says is our person is mentally competent, but they're incapable of the care, custody, and management of their estate by reason of age or physical infirmity, or who has voluntarily petitioned for the appointment. So sometimes what we find this particular statute is useful for is that we have kind of a little buffer. We have our vulnerable person who maybe is, physically handicapped. They may have, or physically disabled. They may have some other challenges, like they have a child who lives with them who's constantly asking for money. So, this just creates a buffer, and it allows our vulnerable person to really takes away the burden of paying their own bills and puts it on our voluntary guardian, who can be a professional guardian. It can be a family member. It can be someone who's a little more removed from the situation to pay the bills. Now, this is only for financial decision-making. So voluntary guardianship can only be used for financial. And then the other thing about it is that we have to have this letter from the doctor. And I'm just going to read this because it is important for you to understand what it says. It says a certificate, the petition shall be accompanied by a certificate of a licensed physician. And by the way, you can just have a letter specifying that he or she has examined the petitioner and that the petitioner is competent to understand the nature of the guardianship and his or her delegation of authority. So we have a form that we use that basically the doctor says, I have examined, Johnny Jones, and Johnny Jones understands the nature of a voluntary guardianship, and he is capable of saying he wants a voluntary guardian. I'm misstating what our letter is much better drafted than that, but that's generally the gist of it. And so what's also cool about this voluntary guardianship statute is you can actually avoid giving notice to people that you don't want to give notice to. So if the exploiter is one of your next of kin, by using a voluntary guardianship, you can actually say, I don't want our exploiter to be noticed with the voluntary guardianship process. So it's basically the person who's our voluntary ward gets to decide who is given notice. In addition, with voluntary guardianship, you can actually decide which assets get put in. So as you can see down here, you may say, I don't need my IRAs in the voluntary guardianship. I don't need, my investment accounts in the voluntary guardianship. I only need my bank, my checking and savings accounts to be in there. And you can actually specify assets to go into the voluntary guardianship that are less than all of our incapacitated or our capacitated persons' assets. And so in that case, the judge will specify that in their orders, what assets get placed into the voluntary guardianship. Now, here's the other thing. You still have all these reporting requirements that are very similar to what you would have to do in a regular incapacity guardianship. You have to include an annual report. What's unusual is that the doctor needs to basically do a writing that says this person still qualifies. They still understand that they understand the nature of guardianship, and they still have the ability to designate someone to take, to continue to manage their assets. What I love about this as well is that it can be terminated, but the ward has to file a notice with the court. And that filing process of the notice sometimes gives us an opportunity that if, okay, our voluntary ward is being exploited now, and the voluntary, ward's undue influencer is, telling them you can terminate this, all you have to do is terminate it. This kind of slows that process down and sometimes gives us an opportunity to convert a voluntary guardianship into an involuntary incapacitated guardianship if that person qualifies for that at this point. Okay, so that's one option, is voluntary guardianship. And moving on, some of the other options are the things that we've already talked about: irrevocable trust-based planning, durable powers of attorney, coupled with designation of healthcare surrogate, coupled with a living will. We always want to get a living will. The other thing about living wills is you can't get hospice until you have a living will. So like for our little guy who didn't want to have a DNR, we can't get him in hospice because they're like, you have to have a living will in order for us to do our job properly. So, the living will is really important, and the DNRs are really important. Oh, we have a question. Okay, Alexis.
We do. So we actually have a question that came in through the Q&A and in the chat.
Okay.
So I'm sorry if I missed it when it came through, but in the Q&A, I'll go there first. The question is, what is the best and easiest way to complete a living will for a senior/parent?
Okay, good question. So living wills, the way we do it is as a separate document. And the reason that we do it that way is because a living will, it's like, this is how I like to explain a designation of healthcare surrogate and a living will. The healthcare surrogate designation, they're the champion. They're like the tool user. The living will is a tool in our healthcare surrogate's toolbox. The decision maker ends up being the designated healthcare surrogate. So we want to have a designation of healthcare surrogate document. The living will says, this is how I want to die. My person to implement how I want to die is there are handyman of death, if you will. The living will just basically lays out 3 different situations when you're at the end of your life. You're in a persistent vegetative state, you're in a terminal condition, you're in an end stage condition, which we don't really know what's going to kill you, but the doctors have said you're at the end of your life. So our designated healthcare surrogate is supposed to look at your living will and implement your living will, also with the understanding of what your wishes would be. So if you were trying to do a living will for a parent or a grandparent, you would want to know what their wishes are, and then you would draft the living will accordingly. Now, we've had living wills that say, I want every measure taken. You know, we want, if I'm at the end of my life and I'm in an end stage condition, persistent vegetative state, or I have terminal cancer, I still want everything done. So, you know, in that situation, our living will would reflect those wishes. And the living will goes to the physician will read it, and then they will, you know, look to the designated healthcare surrogate to actually sign the documents, like the informed consent to do a procedure or not to do a procedure, or to withdraw artificial hydration or nutrition. Where can you find living wills? Look, you can find them on our website, millerelderlawfirm.com. It's free. You can also find them on the Florida Bar. We keep our designation of healthcare surrogate and living will documents updated. We don't charge for that because we think it's important that everyone have them. And, you know, when you go in for a procedure, I just had a procedure about 10 weeks ago. They went through living wills and designations of healthcare surrogate. You do not have to be an attorney to draft a living will. Actually, it's probably better if you're an attorney to draft it. But if there's a form that's at a healthcare facility, you can review it. You just want to make sure that it addresses artificial hydration and nutrition, it addresses resuscitation, and it addresses each of those three conditions. The designation of healthcare surrogate should also contain a provision that allows your designated healthcare surrogate to make decisions for you. This is new to the statute since 2017. Make decisions for you, even if you can make them for yourself. So, like in my circumstances, my mother had pancreatic cancer, and she did not want to go to the doctor to make a decision about whether or not to stent her liver. She wanted me to go for her. And I was like, Mom, we can't, because you have to, if you're competent to make the decision, you have to make the decision. So, you know, what she loved was sitting on the bed playing Barbies with my daughters. So nope, we had to get her up, we had to get her showered, we had to get her dressed, we had to get her in the car, we had to put her in the busy, you know, waiting room. Whereas now with the new provisions since 2017, your healthcare surrogate can actually designate someone to make that decision for you. And they have full authority to go to the doctor's office, listen as though they were the patient, and sign the informed consent. So it's huge. So you want to make sure that that provision is contained in your designation of healthcare surrogate as well. All right, so I hope that answers the question. A lot of people have living will documents all over the place. Healthcare providers have them. You should have no problem finding them. And if you can't find it anywhere, or you want to look at ours, come to our website and we're happy for you to download those and, you know, tinker and make it your own.
And
Okay.
the other question that came in through the
chat
bars, and I'm sorry, I'm looking over here.
No, please, it's a go, good.
Is when should somebody set up a durable power of attorney? When? So durable powers of attorney should be established really when you do any other estate planning. So it is by far, in my mind, the most important estate planning document because it avoids guardianship. And we know that if you reach the age of 70, you have an 85% chance of becoming incapacitated before you die. We also know that people who are of lower income and lower assets also are on average going to spend 6 months in a nursing home before they die if they reach the age of 70. And if you guys know how expensive that is, it can be like, you know, $13,000, $14,000 a month for a long-term care bed. So the importance of a durable power of attorney is that you can then do some things to get people qualified for Medicaid without having to, you know, go through a guardianship process. Because if you have to go through a guardianship process to qualify for Medicaid, it's just an incredibly, you know, painful process and very expensive. So, you know, we always encourage people, first and most important document to get is that durable power of attorney. I think people should have them right away. I think Alexis should have one. She's like 25. No, it really is important because you never know when you're going to hit your head, or, you know, if you know, for some reason, like, let's just say you get in a car accident and all your bills are due on the first of the month, you know, who's going to pay those bills for you?
even if you're just physically, unable to get to the bank. I mean, it's really important to have the durable power of attorney, more important than a will or a trust or anything else. Because we also have a medical proxy statute that is our fallback if you don't have a designation of healthcare surrogate. We just don't have any other way to avoid guardianship except for this document. So it is the most important. So I would encourage people right away.
Awesome. Thank you so much, Shannon. And
You're
those are the
welcome.
2 questions that came in. I'll keep
Okay,
them.
good. I know some people are alive out there. That's good. Okay, so we have 30 more minutes, and I want to kind of bust through a little bit to our terrible, Ellen Cheek and I are going to talk tomorrow a little bit more about the exploitation stuff. We're going to spend quite a bit of time talking about exploitation and what avenues there are in our state to deal with those issues. But a lot of times what we see in guardianship cases, unfortunately, is that we can't really use certain techniques that we would otherwise use when there is an undue influence or when we're talking about exploitation. So let's say we get this case, comes in the door, and what's happened is our little lady, who's had a long-standing estate plan naming her son as agent under power of attorney. Her neighbor, it's a new neighbor, he moved down from Ohio, and yes, this is an actual case that we had, and he befriends the neighbor. She starts using him as her handyman. They become very close. We start to see significant money going to him for these handyman services that look to be excessive. Next thing you know, he has downloaded a durable power of attorney on, LegalZoom or whatever, offline. And so then all of a sudden he puts a lock on our little lady's fence around her yard, and he's the only one with a key. He changes her phone number. He tells her that her kids are trying to have stolen from her and that they're trying to put her in a nursing home, and has her isolated very nicely. And the kids are at their wits' end. They can't even access their mom. They can't call her. It's really a terrible situation. So let's say we get that situation in, and we have this later durable power of attorney document. What are our options at this point when that happens? And also in that case, he also got her to sign over deeds to all her properties, and she had several parcels of property. So what do we do in that case? To me, there's really 2 questions that I'm going to ask myself. Will an exploitation injunction help us avoid a guardianship in a case like that? Because those are really 2 new techniques that we have available to us, especially after July of 2021, when the new Attorney General laws came into effect. Attorney General and Elder Law Section did this provision that allows agents under power of attorney, even if the principal, so our little lady, doesn't consent to the exploitation injunction being filed. Even if our lady is saying, no, my neighbor's the only one who can help me. In those cases, our agent under power of attorney can still file. And, the question would be, well, is that the agent under power of attorney, or is this new document the one that the court should honor? And that will be a question of fact for the court. But I can tell you that what happens in a situation like that, where we see blatant exploitation, is it's likely that the court's going to honor this long-standing estate plan where they had a durable power of attorney there, which is exactly what happened in that case I was referring to. Our judge in that case, what we do with the exploitation injunction is we are able to make a no contact provision for the exploiter. So the exploiter gets out. They can't have third party contact. They can't have phone contact. They can't have physical contact with our victim, or they get a new law violation. It's just like domestic violence. So, that happens first. And then secondly, we can set aside that that bad actor or durable power of attorney under the exploitation injunction process, which again, we'll talk more about tomorrow. So, that is an option, and it's such a great option because, like I said, it allows us to avoid guardianship. We can use this less restrictive alternative, which is the durable power of attorney, once we get the court to clean things up. And in that case, we actually had trust provisions that allowed us to fund all the assets that hadn't been placed in the trust or retitle them into the trust. And then we had all the assets in the trust that she'd already created. So we could use successor trustee provisions. We could use the injunction to avoid guardianship. And then we had the agent operating as a less restrictive alternative in that case. And by the way, you file your injunction, you get a hearing, all of that happened within about 2 weeks. And it was great. So, using those exploitation injunction tools sometimes also can allow us to bypass a guardianship process. Now, that's not always the case. Sometimes the facts are a little more gray, and the court needs to feel like, I'm not sure, maybe this was exploitation, maybe it wasn't, I don't know. So in those cases, we may decide this is a gray fact case. I don't even want to do an exploitation injunction here. I just want to go in and get an emergency temporary guardianship in place. Or if we don't even know if there's been exploitation, but we know that our ward is in danger, right? So we know that for an emergency temporary guardianship, there has to be some exigent circumstances, like there's a big threat of loss here. Someone's name has shown up on a joint account. There's some other things going on, and we can go into court and say, look, we are really concerned about loss here, or there's danger to our person. They may be, are being taken out of state. And we had a case like that recently where we used the ETG because there was actually a plane reservation to move our person out of state. So, all those factors can play into the establishment of an ETG, which is an emergency temporary guardianship. It can last up to 90 days. And the ETG actually allows us to kind of lock the assets down relatively quickly. It can be done almost ex parte, but not really, because you're still going to need to have a court-appointed attorney represent the interests of the ward and to send out some service to the next of kin. But in an ETG, we can still sometimes use our durable power of attorney document if that's been if it's remote enough that we can kind of look to that for the court to honor that power of attorney. And that's kind of the next thing I want to talk about is, how do powers of attorney how do they mesh together with interweave with our guardianship process? And we use them a lot when we have an exploitation case and we want to get rid of an undue influencer or an exploiter. But we want the assets, we want there to be a ruling from the court that our person is incapacitated so that they can no longer make changes to their powers of attorney or their accounts and that sort of thing. We want them to be determined incapacitated because they are, but we also want to use the less restrictive alternative, being that durable power of attorney, because it's so much less expensive. It's been their longstanding estate plan, and it's just going to be easier on our person to administer their assets by using the power of attorney document. So in those cases, what we'll usually do is file an ETG, ask the court to recognize the durable power of attorney document that's attached to the ETG provisions and to the ETG petition. And then when we get to the final incapacity hearing and the guardianship, we will ask the court to enter an order just acknowledging that our person is incapacitated. That would be the order of incapacity, but then appointing a guardian over the person, right? Because durable power of attorney is only over property, honoring our designation of healthcare surrogate over healthcare decision-making. And then for the other personal powers, things like determining residence, making decisions about social aspects. I mean, all of those personal decisions, we ask the court to allow us to appoint a guardian of the person for that purpose. Okay, so that is how we use the durable power of attorney in those cases. Now let's talk about what it looks like when a petition for incapacity is filed and we have a durable power of attorney that's out there in the world. Let me show you the statute on that, because I think it's very important for those of us that want to understand how these two kind of interact. And that is document 3. All right, here we go. All right, so this is what we find in Florida Statute 744, which is, of course, where our guardianship statute rests, is under 744. And so what happened in 2015 is there were some changes where, we were trying to do better with honoring durable powers of attorney that were legally entered. And we wanted them to continue to be recognized when a petition for guardianship was filed, because, they've been longstanding and they, usually involve people who are close in familial relations. So what the legislature did is they created kind of this process where if you are the parent, the spouse, the child, or the grandchild who has filed this power of attorney, right? If you're the agent under power of attorney, or the parent, the spouse, the child, or grandchild of our principal, then your power of attorney continues to be effective even when a petition for incapacity is filed. Now, what we see here in 744-3203 is that there is a process to suspend the parent, spouse, child, or grandchild's power of attorney document if these grounds are met. If the person is an exploiter, if the power of attorney is invalid, if they didn't do their job right, if they gave the agent, if they gave the principal's money away, then there's a process to file a motion to suspend that agent under power of attorney's authority, but only as it relates to these people. So then what we do is we know that if it's not those people, right? So if we know that it's those people and it's subject to suspension, and if there's no grounds for suspension, the power of attorney continues to be effective. But if it's someone for other than the parent, spouse, child, or grandchild, then we go to this statute, which is here. So this is, we have to flip over to Florida Statute 709, which is our power of attorney statute. And this goes through some of the provisions for suspending that power of attorney under 744. I'm sorry, did I do that wrong? No, I'm looking for 709. It's document 4. Hold on. Oh, here we go. Okay, sorry about that. All right, so this is our, basically suspending the authority. And if you look down here at section 3, it says, if a petition for incapacity is filed and basically the power of attorney is suspended until either the petition for incapacity is dismissed, withdrawn, or the court enters an order. So if it's the friend, the neighbor, someone who's not like in your immediate familial lineage, then your power of attorney will be suspended on the filing of the petition for incapacity. So, that's relatively new. And people are not familiar with that. So I bring it up because it is important that we continue to operate as normal as possible with an agent who's operating, correctly. And they can continue to do their thing under the power of attorney, so long as they haven't, really done something wrong with their power of attorney. So that's like a good thing. And then the court can have some time later to kind of vet that issue. But if they're not a close familial person, or if there's someone who's like not in those categories, then the DPOA is automatically suspended. And sometimes we need the ETG to have authority under the ETG orders to manage the affairs of our principal. And then at the end, you may see a reinstatement of the power of attorney. So, that's that. Okay. Is that a new question in our Q&A? Okay. What happens? His question is, what happens to a durable power of attorney if there is an incapacity determination? Excellent question. And that brings us to our next topic, which is, and I'm going to just kind of run through that really quickly. Actually, let's just go right to it because I want to answer your question. So this is 744-331. So let's say that we're doing exactly what the last question was. We have a durable power of attorney, it's been suspended, and now we get to the incapacity proceedings, we get to the incapacity hearing. And if the court basically finds the person is incapacitated, then the court must determine if there is an alternative to guardianship that's less restrictive to address the problems of the incapacitated person. So this is a presumption that if there is a power of attorney in place and the court is, finds that this is an alternative to a guardianship process, then the court really must honor that durable power of attorney. Maybe it's been suspended. That does not mean that the judge can then say, well, I'm just going to go with guardianship because I like guardianships and I want to keep an eye on the assets. No, the judge must consider and find whether there is an alternative to guardianship that addresses the problems of the incapacitated ward. So it's not really an option. If there is a power of attorney that exists, even if it's to someone who's not in the family, the court is required to honor the previously entered durable power of attorney document. And if the court finds there isn't an alternative that sufficiently can address the problems of the incapacitated person, then a guardian has to be appointed to exercise their delegable rights. So, I hope that answers your question. In my experience, and of course I'm in Gainesville, but I also practice out on the beaches in St. Johns County and all over the 8th Judicial Circuit. We practice in Putnam, mostly in North Central Florida. We find that our judges regularly want powers of attorney in play. They like powers of attorney. They may sometimes want to see, some sort of informal accounting, although I will say that hardly ever happens. And I'm usually going to go in and argue with the court about that because it's not required. Basically when you enter that durable power of attorney for yourself, you're saying, I don't want judges in my business. I want my person to make these decisions about my finances. But I do always encourage our agents under powers of attorney. I mean, technically under the statute, under Florida Statute 709, they're really required to keep good records. And if something comes up and a government agency asks them for an accounting, they have to provide it. So I always tell people, like, if you're an agent under power of attorney, just keep some records. I just encourage them to make an envelope that has, May 2022 on it, and in there just put all the receipts, make a note on checks like what this was for. Just do an informal accounting process where you're just keeping the records, because it can be 3 years from now and someone's questioning you as to whether or not you were acting in your good fiduciary duty. They get a call from Adult Protective Services. Hey, we think they've been exploited. And really you haven't. You just, somebody has a beef with you, or they're, it does happen sometimes. And then, if you have those records and you can show them to Adult Protective Services, then, this issue will be resolved. So I like to have our agents under power of attorney just keep some sort of informal accounting system in play. And then, so typically what should happen, what I would say happens in most cases, even more than most, like I would say 95% of cases where we have a legitimate durable power of attorney, and we filed it with the court and asked the court to recognize it as a less restrictive alternative, the courts grant those motions. Now, if there are competing durable powers of attorney and we have, exploitation, it does look like there's exploitation, even though our person under guardianship is saying, I wanted to give them that money, it was a gift, and there's some gray areas and families are fighting. Sometimes our judges will say, we're not going to honor that durable power of attorney because it was too close to, this guardianship proceeding. Or, we're going to appoint a professional guardian who can also look into whether or not our person has been exploited. Then we will see the court set them aside and go with a guardianship process. And sometimes that's like the right decision, because sometimes, what we find once a professional guardian is put in place, and they'll go back and look at their records, they just look at the bank statements, they see, oh my gosh, they've been exploited for the last 10 years. So sometimes, that's necessary. But it is not fun. It's not something that I think anybody in particular in the elder law and guardianship attorney field, we try and avoid guardianship like the plague. But I want to hit on one more little practice tip, and that is, obviously, this is like an ethics part of this presentation. The petitioner who comes to you, maybe a professional guardian, it may be, someone who's a family member or a friend, or, whoever it is, when they come to you and you're the attorney, you have established an attorney-client relationship with that person. So be very careful. If you start all of a sudden drafting estate planning documents for our alleged incapacitated person, but you're also representing this person who may end up being guardian, you're in a difficult dual representation conflict written all over it, problematic situation. So pick your client. Who is your client? Now, we've had situations where someone will come to us and they're saying, I think my dad needs a guardianship. And I run through those questions about incapacity and I realize, well, they have a prior durable power of attorney appointing this person as their agent. And, dad just needs to update those documents. We just need to do an update of those documents. I can consider that person who came to me as the agent for dad, but then I'm going to have only communications that are confidential with dad, right? So that person may put dad on my radar because dad can't hear, dad can't see, dad can't come into my office. They're contacting me as dad's agent, but dad is my client. So I'm glad to know dad needs me, but dad and I are going to have confidential communications to the exclusion of whoever it is that maybe came through the door. So, you do want to be very conscious right away of who is your client, because you cannot represent both a guardian and also do estate planning, like durable powers of attorney and that sort of thing. I have an attorney that I work with quite frequently who, she's a guardianship attorney. And when we have this dilemma come up, she'll call me and say, hey, do you mind talking to this person? And I will say, I don't mind. Can you also talk to this person? And so because we work in the guardianship and also the estate planning world, we can kind of help each other through that process, not colluding, of course. You need to make sure there's a clean break, but having those resources in your community so that you can make good referrals can be very helpful. Because we want people to have separate counsel. We want to make sure that people are not being unduly influenced or forced or coerced to do things that they wouldn't do, but for this voice whispering in their ear about that situation. Okay. Then I did have a couple more things I wanted to cover. Okay, no, I didn't. I kind of covered all of it, which is awesome because we have 7 minutes. Okay, but I have, what's that?
I said that is very awesome. You answered all the questions and got through it.
Okay, but I want to take a minute, if it's okay. I'd like to use my time to continue to educate a little bit. Okay, all right. So we also have, this new tool coming up. And I think that tomorrow, Ellen and I are going to talk more about the exploitable brain, but I've got to talk about it a little bit right now. So the science on the exploitable brain is very, very immature. The science on the incapacitated brain is really good. We actually have clinical tools for the incapacitated brain, right? You've got your mini mental status exam. There's like 7 different types of examinations that we have that are clinically based. They've been researched and vetted, and they do help us determine, whether or not someone is capable of managing their own affairs. The problem with those tests is that they make that specific determination. Are you capable of managing your affairs? Can you make decisions with regard to your finances? Can you make decisions with regard to determining residence, to making medical decisions? All those things have been factored into these clinical tools that are examinations that are conducted normally by a doctor and, either 2 nurses or a nurse and a psychologist or someone. Even sometimes we have lay people who are experienced in incapacity issues. So, we have those tools out there. Okay, what about our exploitable person? And for all of you adult protective services people, listen up, because this is coming, right? If you go out and you're meeting under 415 with our person and you're trying to make a determination as to whether or not they're vulnerable, and they seem fine, they just seem fine, but you've just learned that they gave the neighbor all their real property, they deeded over to him, they've given him the ability to to put a lock on their front gate, and they have made him the agent under power of attorney. But when you're interacting with them, they know their name, they know who the president is, they've checked all the boxes on your mini mental status exam questions or your general questions to assess capacity, right? I mean, it happens every day. I see it in my office every day. Somebody comes in and they've just told me that they wrote a check to Publishers Clearinghouse. Literally, this just happened. They wrote a $140,000 check to Publishers Clearinghouse because some scammer came to their door with one of those big blown up checks and says, you get $1 million if you just write a check for $140,000. This is, we're from Publishers Clearinghouse. They had a van, they had a name tag. These are really good scammers, but our guy is completely capacitated. He's absolutely capacitated. He's gonna sail through a mini mental status. He may get like a 26 or a 27 out of 30. That does not mean he's not exploitable. And the same is true with our clients who are becoming unduly influenceable and becoming exploitable. What we know now with the science is that they're developing tools to assess exploitability. So it's a totally different assessment. It's a different region of the brain. It's called the thinning of the cortical insula. Tomorrow I'm going to go through those 2 small research studies that have really grabbed my attention. I know there's more out there, but the 2 studies that are super compelling, we're going to go through that tomorrow to talk about. No, it's not a part 2 tomorrow, but it's the exploitation part of the program tomorrow. I think it starts at 12:15. And so Ellen and I are going to go through that. But for you guys out there in the trenches, trying to figure out if the person's incapacitated, get ready, because UCF and the University of Florida, Natalie Ebner and Bonnie Levin, who came and testified, came and talked to our exploitation conference a couple years ago about some of the research they're doing. They're getting ready to wrap up this 4-year research study to give us a tool for determining exploitability in the exploitable brain. So stay tuned tomorrow, come to our program, and we're going to talk more details about exploitation. We're going to talk about the tools that exist in Florida. And I just want to put on your radar the difference between the exploitable brain, the unduly influenceable brain. And the way that I like to think of it is whoever talks the loudest to our person, whoever speaks with the most frequency to our person, whoever convinces them of this theory that they have, and they just repeat it again and again. Your kids are stealing from you. They want to put you in a nursing home. I'm the only one who will keep you out of the nursing home. I'm the only one who cares about you. And they isolate, and they've got you just believing this big lie. That ends up being something that we can now potentially have a tool to assess. So I'm very excited about it.